starting in 5 seconds. The submission of learned counsel for the petitioner is that the allegations of infidelity against wife made by the husband are a counterblast of the proceeding initiated by wife for illegal demand of dowry and claim of maintenance. The allegations leveled in divorce petition are without any basis. Sufficient documentary evidences have been filed before the family court to substantiate that the child was born out of the wedlock of the parties, and the allegations of wife having illicit relationship with another man are baseless. Submission is that the family court could not have ordered for conducting DNA test in a routine manner without applying its mind on the evidence brought before it merely on the basis of allegations made in the divorce petition. Learned counsel for the husband, on the other hand, placed reliance upon the judgment in Deepa Rao Supra to submit that the apex court in that case had directed that in case of allegations of infidelity of wife, it would be impossible for husband to establish and confirm the assertion made in the pleadings. DNA testing is the most legitimate and scientifically perfect means which a husband can use to establish his assertion of infidelity. It is most authentic, rightful, and correct means, and also for wife to rebut the assertions of her husband and to establish that she had remained faithful, not adulterous, and loyal to her husband. The clear picture would be drawn by conducting DNA test, and if wife is right, she shall be proved to be so. She can have no objection for DNA testing, which would definitely prove that legitimacy of the child. Considering the submission of learned counsel for the parties and the facts noted above, a specific query was made from the learned counsel for the husband as to the stage of the divorce petition. Some of the evidences filed by the wife enclosed in this petition have also been taken into consideration. Having considered the nature of allegations and the evidence filed by the wife, this court is of the prima facie view that the questions as to whether the child was born out of the wedlock of the parties and whether the allegations of infidelity are false has to be examined on appreciation of evidence in the divorce petition. As per own averment of the husband in the divorce petition, the fact that the marriage of the parties solemnized on 28 June 1999 was consummated. The allegations have been leveled against wife on account of premature birth of the child after a period of 7 months from the date of marriage. The assertions in the divorce petition are that the wife had admitted that the child was illegitimate. The question before the family court, therefore, would be to find out to who is telling the truth. The evidence led by the parties have yet not been examined by the family court, and it had proceeded to direct for conducting DNA test in a mechanical manner. Stop.